Welcome to Mandates and Megaphones, hosted by Jeremy Maggs, unpacking the politics, promises and power plays behind the G20 summit.
Hello and welcome to Mandates and Megaphones in association with Standard Bank. It's the podcast where diplomacy meets disruption, where geopolitical choreography is colliding with economic ambition, where emerging powers demand more than just a seat at the table. I'm Jeremy Maggs. Now, this is going to be an interesting one. As South Africa prepares to host the G20 summit, a hard question, I think, is cutting through the event. Are we protecting those who speak up when the system fails them? Or are we still trading in rhetoric while whistleblowers pay the price? Our guest today argues that this is the moment to move from promises to protection, not just for our credibility at the summit, but for the health of our democracy. In that respect, I'm joined by Tebogo Khaas, who's Chairperson of Public Interest South Africa, also convener of the 2025 Whistleblowers Awards and Summit. And he's calling for urgent, tangible reforms to shield whistleblowers as South Africa assumes the G20 spotlight. Tebogo, a very warm welcome. And you write that as G20 host, South Africa, and I quote, "you cannot afford to let whistleblower protection remain rhetorical." In your opinion, then, what specifically is rhetorical right now, and what would concrete action look like before leaders start to arrive in Johannesburg?
Yes, and thanks for that question, Jeremy. And you would recall that we have been talking about amending the legislation, and the politicians, or government rather, has actually teased us, if I may use that word, to their concern and inclination towards doing just that, that is amending the whistleblower legislation framework. And we haven't seen any movement insofar as that is concerned. In fact, more than 2 years ago, when we first had a discussion with the Department of Justice, for example, approaching them on how to improve the whistleblower ecosystem and giving more protection to whistleblowers, there was lip service given, and insofar as we are concerned, because after the issuing of the discussion document on whistleblower protection, we haven't seen any movement at all. Although I might gain a sense that there may very well be the talks behind the scenes, but we haven't seen any movement. The fact of the matter is that it has already been more than 2 years since the discussion document was issued, and we haven't seen a bill yet. So that is the rhetoric that we are talking about when we talk about it's all talk but no action. And in the meantime, whistleblowers pay the ultimate price in some instances, unfortunately.
So the second part of the question is, what kind of concrete action do we need before leaders start to gather in Johannesburg?
Well, what government needs to do, we need to see a bill tabled before Parliament for comment to start with, and ensuring that with the same fervor that was seen happen when the Scorpions were disbanded, to see this legislation actually fast-tracked through the parliamentary system. We understand that there's a process, there are procedures that need to be followed, there'll be hearings, a need for hearings, but this is a singular, important moment that can be used to actually put to life that which was first mooted in 2020 in Japan, when Japan had the presidency of the G20, to say, whereas Japan had started this high-level principles for effective protection of whistleblowers, South Africa actually moves to ensure that it aligns its legislation with those principles. And this is an opportune moment for South Africa to come out above the parapet and say, we are leading this race.
Tebogo Khaas, I wonder if you can give me a little bit of broader, maybe global context. To anyone listening to the start of this conversation, this might very well sound like a local or domestic issue. Yet, why is this important within the G20 context, given that democracies around the world and the principles of democracy are under so much threat?
Jeremy, we live in a global world, a global economy. And what happens in one area of the globe actually does have an impact on others. If we look at it, we've got multinationals operating within the context of South Africa, and we've got citizens also. Work happens on the go, where people are migrating and actually working remotely also in different jurisdictions. So if there's no alignment insofar as whistleblowing, legislation is concerned across jurisdiction, you will find that enforcement or protection of whistleblowers becomes very difficult. I'll give you an example. You might find that in certain jurisdictions, let's say Dubai, they might very well have no such protections for whistleblowers as South Africa would have. So if a multinational that is domiciled in Dubai, for example, as a financial bloc, they might very well say, look, we are immunized from whatever happened or whatever we've done in other jurisdictions. In other words, we are beyond the reach. And whatever happens to those who blow the whistle or make those protected disclosure, it might not affect us. So we need to ensure that there's a global alignment of sorts to ensure that at least G20 members themselves lead the way insofar as amending the legislation, making sure that it aligns with the principles that we've talked about, the ones that were first introduced in Japan.
Tebogo, so many competing agendas as far as the G20 is concerned, so many global priorities. It's going to be difficult, though, to get an issue like this onto the blueprint, surely.
No, absolutely. But remember, the common thread which permeates throughout is anti-corruption. So we can talk about whatever economic ideals or commercial things that are imperative for each country or each nation. But if we do not deal with the elephant in the room, that is improving anti-corruption efforts, it means nothing. We've got today the Interpol sitting in Cape Town, for example, for a conference. And if anti-corruption does not feature centrally within the G20, it means any efforts to improve the economies of the world will just be faced with the kind of problems because we know that corruption is not a victimless crime. We know that most jurisdictions suffer economically because there's repatriation of funds unlawfully or using very nimble-footed type of practices. And that also has got a pernicious impact or effect on economies, especially of the global south or the emerging economies themselves. So it is important that anti-corruption, and in this instance, the fight against anti-corruption can best be bolstered by ensuring that whistleblowers get to actually be protected or play a central role in whatever discussion or efforts towards fighting corruption.
What's your general sense as we approach the G20? Is this something that might be taken seriously?
Speaking honestly, I doubt it. I hate to be saying that because I actually should be sounding more optimistic. But we are still hopeful that it should be taken seriously. But the question is, as a presidency of the G20 and South Africa, with the track record that we've demonstrated this far, insofar as government is concerned, what would give us any hope that things will be expedited this time around with a few months left for the G20 presidency to actually change hands and be handed over to the U.S. And remember, now the U.S. might take a very different attitude altogether, although the U.S. has in some instances also led the way insofar as protecting whistleblowers and incentivizing whistleblowers, as we've seen with many cases through the SEC, Security Exchange Commission, where whistleblowers had been provided with incentives to blow the top. But we're not hopeful that South Africa can do it because our pace itself, we just can't even organize a simple thing like a national convention without problems. You can't organize a Madanga Commission infrastructure without a problem, without issues. So something like this might very well be a long shot, but we are still hopeful that it can still be done. So South Africa can come out and shine and say we've led the way or we're leading the way insofar as this issue is concerned.
What are the consequences if we don't get to grips with this issue?
The consequences are dire. It's a question where we find that witnesses will find it difficult, or rather they will be disincentivized to actually come out and attest before courts. And we still know that a lot of the Zondo Commission matters are still to come to court. So there are witnesses who may not necessarily enjoy the witness protection status as per the Witness Protection Act, which also needs to be looked into, because until a matter is enrolled before court, it might very well find that it may not trigger the kind of protections that are accorded witnesses. That is point number one. So that is also part of the whole legislative regime that needs to be overhauled. And then it's going to also affect those who are already before courts now, who might very well want not to proceed with providing testimony against those under the criminal process. For example, if you look at the allegations against Vusimus Matlala, you might very well find that there are other people who could provide testimony that could ensure that the state's case is strengthened. But if they know that the minute I raise my hand, I might very well be targeted and there's no protection, or my livelihood will be affected and there's no way that I'll be compensated, people are just not going to come out and support or give testimony. So it is important in the sense that in the broader fight against crime, in the broader fight against corruption especially, we need to ensure that whistleblowers are emboldened and are protected, not emboldened so much, but protected, and offer the kind of incentives that will make it easier for them to come out and speak.
Let's talk about incentives in just a moment, but let me just remind you, in association with Standard Bank here on Moneyweb, you're listening to Mandates and Megaphones, and I'm in conversation with Tebogo Khaas, who is Chairperson of Public Interest South Africa, as we look at the importance of whistleblowing as far as the G20 agenda is concerned. As I said, let's come back to incentives in just a moment, but are you not surprised, given that the G20 promotes transparency and anti-corruption, that's embedded into its DNA or perceived DNA, why whistleblower protection has not become a binding commitment across member states?
Yeah, it's a question that we all grapple about, because if indeed that is what underpins the G20, you ask yourself, why are member states not called to account as to why the legislation does not yet align with those principles? I mean, we're talking here more than 15 years since these principles were first established in Japan. And you ask yourself, what is taking so long? Why is it that member states are not moving forward to ensure that this copy? Could it be that there's no enforcement of this type of principle? There's no mechanism of peer review and making sure that there's compliance. And there may also very well be that each nation has got their own priorities, and they prioritize those issues before that which they ought to be, that is, in this instance, protection of whistleblowers. But we are encouraged that at least some of the large economies seem to be sensitive to the issues of whistleblower protection. I've alluded to the U.S. There seems to be, a movement in a greater awareness and sensitization that whistleblowers are important insofar as a key to fight crime and wrongdoing.
But sensitivity to an issue, I'm sure you'll agree, is simply not enough. And the real problem here, I'd suggest to you, is that there are vast differences in culture and political will across G20 countries. And that, Tebogo Khaas, hinders the creation of any kind of universal whistleblowing framework. It's going to be very difficult to achieve anything.
No, you're quite right. The business culture says that in some jurisdiction it is okay to bribe a public official, or it's ingrained in how people do business. So actually the culture shock that will be required for people not to adapt might very well be that it becomes difficult. But in some jurisdictions, within the G20 itself, it is intolerable for corruption to be introduced or be perpetrated within their economies. And perhaps those are the voices, or those are the examples that should be used to help those who may be lagging, such as South Africa. We're not saying we are far behind. Don't get me wrong. We've got the PDA, the Protected Disclosure Act. It's got its own weaknesses, which we are saying it needs to be overhauled. We've got various pieces of legislation from the Labour Act and many others where we say there needs to be coherence in how legislations talk to whistleblower protection. And yes, it is the priorities. We need to actually make sure that we prioritize that. But we've got a presidency or an administration that doesn't seem to want to act with any speed whatsoever in issues that are of public interest.
You referenced the Zondo Commission, Tebogo, a little earlier, and its proposal of incentives and other safeguards, for instance, a fixed percentage of recovered monies for whistleblowers, and there are others. Let's go back to your thinking on incentives, if we can. What kind of recommendation would or could be implemented, again, with more of a blanket approach, which would maybe move the agenda or the issue higher up the agenda, if you understand what I'm saying?
Yes, no, you're quite right. The quantum would be very difficult for one to just off the cuff just to say this quantum or this percentage would be. But, for example, the principle is that funds that are recovered currently by the SIU or any other state agency tasked with that go into the Civil Asset Recovery Fund, the CARA Fund, and they go back into the national treasury, into the fiscus. You ask yourself, if Eskom or SIU was able to recover billions or hundreds of millions from an Eskom corruption-related thing, and there's an individual who blew the whistle, I'm just using Eskom as an example, why is it that that person still finds themselves unemployable today? Because the attitudes of the people seem to not want to absorb whistleblowers into the employment ranks. And yet, you're saying, why is it that the state can benefit, but the person who blew the whistle, whose testimony or whose evidence was very well key in ensuring that the state gets to be alerted about this wrongdoing and be able to recover the funds, but that person is left destitute, some of them having to face hardships that include having their kids thrown out of school or their houses being taken by the banks and all that. And you say to yourself, a certain percentage, surely we can use the model as is the case in the US. And once that is the case, it becomes easier even for law firms or lawyers to be able to come to the fore and assist the whistleblower on risk, knowing full well that based on the strength of the whistleblowing, there is a strong likelihood that they would be able to get rewarded for their efforts and therefore being able to settle the bills. Because currently we've got whistleblowers who are facing hardship because of the legal fees that they have to pay themselves out of their own pockets. And that is something that has to come to an end.
Let me pivot slightly and put this line of thinking to you. There is a suggestion that the G20 might consider establishing a global whistleblowing fund, or at least a safe channel for cross-border reporting, particularly when it comes to multinational corruption cases. Do you think an idea like that would fly?
No, absolutely. It would fly. And we also need a regime because currently, using a US as an example, a US domiciled multinational operating in South Africa is found having committed a crime or injured our economy. Often it is the US economy or the Justice Department that benefits from any fines that may be levied against, though even where under the dispensation of deferred prosecution agreement, for example. And you're saying yourself, there needs to be a regime where the countries or the economies that are hurt by those conduct of those multinationals get to actually benefit from this. So there needs to be a harmonizing of sort. We do understand that in some instances, the instances where National Treasury would, or the DOJ in the US DOJ would actually repatriate some of the recoveries. But most of the time, we find that the large part of it, the large chunk of it, actually remains in the US. The same question that is before courts, before the Constitutional Court now, but it's unrelated. But if you use an example of the alleged currency manipulation case, where the economy of South Africa is being injured, and yet the issue of jurisdiction is central because those affected or those who are accused, some of those accused are actually saying, you've got no jurisdiction over us. So to harmonize the legislation on the whistleblowing to be globally, I think is a good thing, and that is something that we should actually encourage and hopefully make sure that it actually finds resonance and implementation this time around.
And another idea that's floating around is the possible integration of whistleblowing into ESG standards, particularly in sectors like banking, mining, and tech. Is that something that the G20 might want to grapple with? Absolutely.
But, there's commercial interests that sometimes also tend to cloud or to muddy the waters. In fact, much as a lot of focus has been on the public sector, we've seen the attitude of the private sector, which is not very much supportive in practice to whistleblowers. We've seen whistleblowers being treated shabbily, especially in the private sector, where if you report any wrongdoing from one financial institution, they're likely not to be employed anywhere else. I don't want to mention names, but there was one individual who blew the whistle on some bad practices by a bank, one of the large banks, and it's been many years ago, but even today they find themselves not being able to, unemployable in the sector. So there needs to be a reckoning of sorts, because the very corporate that may very well be saying they are against corruption, but when they see whistleblowing within their fold, they tend to close ranks and not want to actually support who blow the whistle. And it's about time that such inconsistencies or such ironies, if I may use that word, are actually exposed and make sure that the financial institutions themselves get to also sing the same tune as is expected of government and not to be treated any differently, because we are currently still under the throes of grey listing, and often we know that most of the transactions that are affected by grey listing actually happens through the banking system. So whistleblowing should be encouraged and practiced more robustly in the private sector, especially the financial institutions.
And I imagine also bedeviling the problem on a global stage is it would be difficult for the G20 to realistically push for whistleblower protection, where in some instances press freedom and civil liberties are under pressure.
Yeah, that's right. If you look at, use China as an example, we all know that, we don't enjoy the same freedoms in China, or Chinese don't enjoy the same press freedoms as they would maybe in other jurisdictions, including South Africa or others. So the question is, how do you make sure that there's enforceability? How do you make sure that there's a mechanism that makes sure that press freedoms, which are quite central, because if it's not for the press, much of these things can actually be thrown under the rug. I mean, we know recently about the efforts of press media houses such as Daily Maverick in terms of uncovering the kind of malfeasance that they've uncovered. You ask yourself, if there's no freedom to report, especially where malfeasance affects government, and you might very well find that press freedom is actually an instrument or a key or pivotal part of the whole regime, that needs to be ensured. But how do you enforce that? That's a big question. How do you make sure that regimes that don't aspire or that don't support press freedom or don't practice press freedom actually get to align? How do you enforce that? But even in jurisdictions where there might very well be press freedom, such as in the U.S., which is now actually receding into dictatorship, you ask yourself, how much press freedom is it in peril, as we've seen how the Trump administration's attitude towards press freedom, is the U.S. still the same as it was a decade ago?
So let me put a final question to you, and let me pick you up on that word enforcement. Let me put this to you, that if the G20 is serious about curbing corruption, do you think it could consider making whistleblower protection a measurable benchmark, maybe similar to GDP or climate targets, and something that is also subjected to annual peer review? What
would it take, I would imagine, is something such as an index of sort, where there are metrics or matrices that are put in place to measure the whistleblower attitude, the whistleblower performance of each member. So such an index should actually be easy to actually implement, because using different factors such as whether there's legislation in place that meet all the requirements, that match all the principles of the G20 insofar as whistleblowing is concerned, and also whether the said government or said nation does retaliate against or take a dim view, or what is the attitude towards retaliation, be it in government or private sector. So such an idea would certainly find favor, and it will be something that, if implemented and adopted, it would very well make sure that there's a benchmark, and corporates operating throughout globally in for example, they'll know that they'll be measured against the same tool. I'm talking about multinationals here. And it will be seamless and easy to, but how do you enforce that? I think that's what the G20 countries need to be, because I'm not so sure what enforcement mechanisms or consequences I put in place for countries that are regressing or countries that may not necessarily comply with such expectations.
Well, certainly a challenging conversation. Tebogo Khaas is the chairperson of Public Interest South Africa, and thank you very much for joining me. Let me conclude with these words. As we prepare to host the world, this conversation is reminding me that integrity at home is the bedrock of credibility abroad, and protection that arrives after a funeral is no protection at all. So I think the next few weeks are going to be a real test, not just of speeches, but, as Tebogo has mentioned, our very will. You've been listening to Mandates and Megaphones here on Moneyweb in association with Standard Bank. I'm Jeremy Maggs, and thank you for listening.
Thank you for listening to Mandates and Megaphones. You can find more episodes on moneyweb.co.za.